right. So we're going to talk today about revocable trusts, irrevocable trusts, and special needs trusts. And all of those things can be interactive to some degree. They can, the special needs trust is irrevocable. There's revocable trusts that are not special needs trusts. There are irrevocable trusts that are not special needs trusts. And anyway, it can get a little crazy. So let's get into what the difference is and what these things are going to maybe be helpful for or not helpful for various individuals. All right, next slide, please. The first thing that we want to talk about when we're planning for anybody with disabilities is kind of what their situation is. As I said, we want to focus on what's important for a particular individual and what their needs are. So we have lots of different tools that we can use when we're planning for somebody. We can use what's called an irrevocable income-only trust, and that's something that the beneficiary creates for themselves. Those are used in particular circumstances for individuals that are maybe receiving proceeds from a lawsuit or a gift or funds that are coming directly to them. We can create an irrevocable special needs trust that is created by the beneficiary. And again, it's a little bit different. The irrevocable income-only trust is not necessarily protected from Medicaid or Social Security, whereas an irrevocable special needs trust is protected or should be protected. And again, those are trusts that we use for people when they are the beneficiary of the trust, they're the person with the special needs, and yet they own the asset that needs to go into the trust. An irrevocable special needs trust created by a third party is used when we have money or assets that are not owned by the beneficiary, but the giftor, the grantor, wants to give to the beneficiary, but we want to bypass the beneficiary actually ever obtaining individual ownership. Again, this is a protection for Medicaid and Social Security. And then we have an option called a testamentary special needs trust. What I tend to use the terms, the testamentary special needs trust is a trust that's created by somebody's estate plan. It's embedded usually in a will, and it doesn't exist until that person dies, and then their personal representative sets up the trust for the individual who is the beneficiary. We also have what's called a standalone special needs trust, or at least that's what I like to call it. I think it makes it easier to distinguish. And those are the irrevocable special needs trusts that I talked about just a moment ago that are created by the beneficiary or created by a third party. And those are trusts that are in existence at the time that that person decides to create them and execute them. And they can be in existence before the person dies, and they can live long after the grantor or passes away, and are a great vehicle to collect assets for an individual that you don't have to wait until someone dies in order to collect those. And we'll talk more about that in a little bit more detail as we go along. We also have a wonderful tool called an ABLE account, and I am going to touch on that a little bit because it is a type of trust, and it does allow individuals who are receiving Social Security and Medicaid benefits to have a little bit more than the $2,000 limit that they typically have, and it is a great tool to use either alone or in conjunction with a special needs trust. And so it's an important thing that we can use in our toolbox to set up the best possible plan for an individual with disabilities to have the assets that they need throughout their lifetime. Next slide, please. My handy dandy helper, moving my slides forward for me. Maybe. There we go. All right, so when we're talking about what's going to be the best tool, how is this going to work best for an individual, we want to know what type of assets they have and what kind of income or resources they have available to them. A lot of times people will come into my office and I'll ask them if they receive Social Security, and they say yes, they are their loved one. And I ask them what kind of Social Security, and they give me a look like I'm speaking in some random, ancient Sanskrit type language or something. There are 3 different kinds of Social Security, excuse me, that an individual can receive. The most common one that people hear about and know about is a typical Social Security benefit that is received when somebody retires. They hit that magic age of, that the government has set, 65 typically right now, and they have worked enough quarters that they qualify for Social Security because they've been paying into it for their entire working career. And they're eligible and they receive that benefit, and it comes to them whether their normal income is $1 or $10 million. They're still eligible to receive that benefit from Social Security because of their work history. And that's typically not the type of Social Security that folks with disabilities are receiving. More often than not, they're receiving either SSDI or SSI benefits. And there is a difference, and there's difference in the benefits, and there's difference in what is necessary to qualify for those two different categories of Social Security. So it's important to know not only that whether the person is receiving disability, but what kind of, or excuse me, Social Security, or what kind of Social Security benefits they're receiving. We need to know whether they're receiving veterans benefits, either as a disabled veteran or as the spouse of a veteran or a disabled child of a veteran, because that will impact the options that we have for them. We need to know whether they're receiving Medicare. Folks who are qualified and receive Social Security disability income are entitled to receive Medicare benefits after 2 years of receiving their SSDI. Even if you're not 65, even if you wouldn't qualify by age, you can still receive Medicare benefits through the Social Security Disability Income Program after 2 years of being a recipient. So it's important to know, are we getting some health benefits through Medicare? And of course, we want to determine whether someone is receiving Medicaid. And all of these things can be opportunities that people have all in conjunction with one another. It's not uncommon for someone to be receiving SSI benefits and Medicaid. It's not uncommon for them to be receiving SSDI, Medicaid, and Medicare. And if you have someone who is receiving SSI and is also over the age of 65, they may also be receiving Medicaid and Medicare. So a lot of these things work in conjunction, as do food stamps, a housing subsidy, and whatever type of health insurance that they may have. Sometimes people may have private health insurance as well as Medicare, or excuse me, as well as Medicaid. And we need to know that so we can figure out how best to make sure that we're covering their needs and and making sure that we're taking care of them. Next slide, please. All right. So we'll start with special needs trust, because that tends to be the kind of trust that most people would be inclined to need if they have a family member with special needs. Typically, when someone comes into my office and they say they think they need a trust, and we talk about why they think they need the trust, we want to talk about the 3 main reasons that we create trust for people. And of course, there's always exceptions and there's always different circumstances. As I said before, there's no such thing as one size fits all for these. It's all very dependent upon what individual situations are. But typically, if we're going to create a trust for someone, it's going to be one of 3 reasons. Either they have a whole lot of money in assets, and I'm talking like $11 million, and we're trying to avoid estate tax, and so we want to create a trust situation to help alleviate the estate tax. Or they have a blended family, and they want to make sure that the children of both spouses are taken care of appropriately, and that it doesn't all end up with one spouse's side or the other. Or someone in the family has a special need, and we need to protect their resources so that they continue to receive their medical benefits, their Medicaid, and their Social Security. So for purposes of this conversation, excuse me, I'm going to focus on the special needs trust. If you feel like you need a trust for another reason, we can certainly talk about that in a different setting. But I want to focus today on special needs trusts and the different kinds that are available and how we get those suckers set up. So we have a self-settled special needs trust, which is a trust that is created by the beneficiary. The beneficiary, of course, is the person who is going to receive the benefit of the trust, the person who is going to get things paid for or things taken care of for based upon the assets that are contained in the trust. We can also set up what's called a self-settled pooled special needs trust, and we'll talk more about what a pooled special needs trust is here in a little bit. They're a different kind of trust that is managed by a not-for-profit entity. We have a third-party settled special needs trust, which is also a format of the same special needs trust as the self-settled trust, but it's being created by somebody other than the beneficiary for the benefit of the beneficiary. Same thing with a third-party pooled special needs trust. And then we have the testamentary third-party special needs trust, which is, again, the one that's created by somebody's will. All right, next slide. Anytime we create a special needs trust, no matter what kind it is, and all the ones that I just talked about on the previous slide, this is the same for every single one of them. Trusts have to be in writing. We cannot have oral trusts. That doesn't work. New Mexico does not recognize them. The distributions have to be discretionary by the trustee. That means that the beneficiary of a special needs trust has absolutely no authority to force or direct the trustee to make a distribution. The trustee has complete 100% total authority to make the decision whether or not they're going to distribute any assets from the trust to the beneficiary. And that is huge because the Medicaid requires that this provision be included in all special needs trusts, because if the beneficiary has any control over the distributions, then it's considered that the beneficiary directs the trust and it's not an exempt asset for qualification. So it's incredibly important that the language be correct in the special needs trust, that the distributions be discretionary by the trustee. That means the beneficiary is not entitled to receive income or principal. They can't go to court and say, well, it's my trust and I want the money, therefore I am entitled to get it. They're not. And that's, again, has to be very clear and specific in the trust in order for it to qualify to be an exempt asset for Medicaid and Social Security. It's completely a discretionary act on behalf of the trustee. So when we go through and we're selecting who our trustee is going to be of these trusts, it's really important that we make sure that we're picking someone that we trust and is going to use their discretion appropriately. We can certainly, if the trustee is being completely ridiculous and not providing funds for things that are necessary and appropriate when the funding is available, they're just being nasty for whatever reason to say no, then absolutely the beneficiary can take that to the court and say, hey, this is ridiculous. This makes sense. I need this. It's appropriate, and the court can direct the trustee. But that's expensive. It's difficult. It's time consuming, and it's not really what's intended by the creation of the special needs trust. So it's important to make sure that we're selecting a trustee who's going to do the right thing and use their discretion wisely and appropriately. All right, the trustee is also prohibited from making any distributions that would jeopardize the beneficiary's eligibility for benefits. That means the trustee is not allowed to use the funds in the trust to pay for anything that Medicaid, Medicare, or if the person is qualified for Medicare, or Social Security would pay for. That means if the beneficiary needs a surgical procedure and Medicare or Medicaid would pay for that, the trustee cannot pay for that out of the trust. So this comes up more often on more unusual treatments or medical equipment that an individual may want or need. I always recommend that if a client feels like they want something and it could be potentially paid for by Medicaid, Medicare, or Social Security, start by making the request. Say, hey, I want this really cool high-level wheelchair, or I want to try this experimental treatment, whatever it may be. And if you get denied and you have that nice denial letter from Medicaid, Medicare, or Social Security saying, no, we're not paying for this, then the trustee is able to go ahead and pay for that if it's appropriate. If there's any question about whether one of those entities, governmental entities, might pay, get that denial letter up front, and then you're covered if they come back later and say, oh, wait, no, we would have paid for that. This is an improper distribution. You're covered. And the disabled individual must be the sole beneficiary of the trust during his or her lifetime. You cannot create a special needs trust for more than one person. So you can't have two kids that maybe both have disabilities, but they're receiving benefits from the same trust. You can have what's called remainder beneficiaries or contingent beneficiaries. And those are people who would be recipients of anything that's left in the trust at the death of the primary beneficiary. And that's okay. We can set that up, especially with a third-party trust. It's a little different with a first-party trust, but we can set that up with whatever the individual wants or the family wants. But the first primary beneficiary of the trust can only be that one person. It cannot be more than one during their lifetime. And it absolutely must be irrevocable. That means whatever goes into the trust stays in the trust and is only used for the benefit of the beneficiary. You can't put something in the trust and then change your mind and decide you don't want it in the trust anymore. The assets in the trust can be changed. For example, if the trust owns a house and the beneficiary doesn't need the house or want the house, or they no longer are appropriate to be in the house, that house can be sold, but the proceeds from the house then have to go into that trust. They can't be distributed in some other fashion. So once it goes in, it stays in, and it's only used for the needs of the beneficiary, and the trust can't be revoked or changed at that point. Now, you can have more than one special needs trust, which is a little different than ABLE accounts, which we'll talk about in a little bit. So if there's a problem with a special needs trust once it's created, and there's concerns about some language that may be in it and we can't change it because it's irrevocable, then we can always just create another special needs trust and kind of leave the other one to the side. So depending upon the situation, again, everything is very fact specific, but depending upon the situation, there may be ways to address problems if they arise with the trust itself, because irrevocable really does mean absolutely irrevocable. Next slide, please. All right, I gave you some of the United States Code citations up here, not because anyone in their right mind would ever want to go and read these provisions. They're painful to get through, but a lot of times you might hear reference to a D4A trust. And so if someone is talking to you about a D4A trust, this is what they're talking about. It's a provision in the United States Code, which is the laws that the Congress has passed, that allows for the creation of special needs trusts. And this D4A is particularly regarding a self-settled special needs trust, and the eligibility requirements for somebody and the requirements for what the trust has to look like in order for it not to be counted as a resource. So in order to make it not countable and the assets in there not be included in counting what someone has for Social Security or for Medicaid, the trust has to be established by the beneficiary themselves, a parent, a grandparent, court, or a guardian. Aunt Sally can't create a D4A trust. The next door neighbor can't create a D4A trust. It has to be the beneficiary themselves, a parent, grandparent, court, or guardian. Sometimes in court proceedings, especially in a personal injury lawsuit, the court can direct that it be created. I have a case currently where I have a guardianship proceeding and a guardianship and conservatorship proceeding, and as part of that, the court has directed the creation of a special needs trust for the beneficiary, for the incapacitated person. So if we don't have a parent, a grandparent, or if the beneficiary doesn't have the capacity to do this on their own, we do have the court or a guardian, if one has been appointed, who can do that for them. This trust must be for the benefit of the disabled beneficiary, and how you are determined to be, whether you're determined a disabled beneficiary, again, I gave you the provision of the US Code that sets that out. But I can tell you, if you've already qualified for Medicaid or Social Security, then you're going to meet that definition. And please don't go and try and read that, because it is really mind-numbing. The beneficiary has to be under the age of 65. This is not a requirement in all states. It's part of the US Code. Some states allow other things and other ages. New Mexico does adhere to this, and we cannot create special needs trusts for people over the age of 65. It's frustrating a lot of times if we have people that may have had a disability for their entire life and have elderly parents who are now looking at end of life, and they're 95 years old, their child is 67 years old, and they want to create a trust for them. We can't create this type of trust for someone over the age of 65. When it is a self-settled trust, it is what's called a Medicaid payback trust. And that means that at the death of the beneficiary, The state is going to be reimbursed, state Medicaid agency is going to be reimbursed for any of the funds that the individual or that was paid out on behalf of that individual. We try to avoid D4A trusts because most people don't want the state to get whatever might be left in the trust. We prefer to do a non-Medicaid payback trust, which I'll talk about here in a little bit, and how the difference is determined. But it's important that we have the right language in there in order to make sure that it's not going to be counted as a resource. But we also want to make sure we protect the individual for as much as is paid for Medicaid. Sometimes people will ask me, well, if I only get Medicaid for a short period of time and my estate, my trust is worth a lot more than that, are they going to take the whole thing? And the answer is no. Medicaid can only be reimbursed for the amount that they actually spent. So if they only spent a small amount on the individual and their trust is greater than that, then they don't get to take the entire thing. More often than not, people who have special needs trusts have had them for quite a while, but they've also been using Medicaid resources for quite a while. And it does tend to eat up most, if not all, of what's left in the trust. So the important thing to keep in mind about a D4A trust is the very first line. For countable assets of a beneficiary, okay? These are assets that the beneficiary already owns. If a will says that I want to leave 20% of my estate to Sally, and Sally is a disabled individual who would qualify for a special needs trust, that is a resource that belongs to Sally, and that is going to have to be put into a D4A trust in order to protect that resource. Same thing with a personal injury lawsuit. If the beneficiary is the owner of the assets at the time that we need to create the trust, it has to be a Medicaid payback trust. Next slide, please. All right, D4C. Again, I wanted to give you the citation so that when you hear the words D4C trust and you're like, what is the heck are they talking about? This is again where it comes from, the United States Code. So this is the provision of the code that allows for a pooled trust. And pooled trusts are actually a pretty cool opportunity for folks. It is a trust that is created by a nonprofit, a 501c3. We have several in the state of New Mexico. One is ARCA and the other is the ARC of New Mexico. They both run pooled trusts. ARCA primarily focuses their pooled trusts on their own clients, and they take pooled trusts for their own clients, whereas the ARC is more expansive and will take pooled trust for pretty much any individual that qualifies for a pooled trust. The nice thing about these is they're managed as a pool by the organization. So you don't have to pick a trustee. The trustee is the nonprofit. You don't have to worry about managing the resources that are in that trust. They're managed by the nonprofit. And you don't have to worry about the size of the trust. Sometimes if someone doesn't want to or isn't able to manage a trust for their loved one or for themselves, they don't have a trust that's large enough for someone to ask a professional. One of our, Heritage Trust or Zia Trust or New Mexico Bank and Trust, those entities typically administer significantly large trusts. I think, from my understanding, about a $500,000 trust asset is as small as those entities will typically go. Some of them require even higher, up to $1 million as a bare minimum. So when you have a smaller amount of money and you can't use a professional trustee, but either the parent doesn't want to or isn't able to manage it, or the family member and the individual can't, a pooled trust is a great alternative because the funds are managed for you. They're invested as a pool, so a lot of times they can generate even better returns because you've got much more money that they're able to work with. And then you don't have to worry about the day-to-day accounting and taking care of that trust. Again, they have to be irrevocable. They can be created by the parent, the beneficiary, the grandparent, court, or guardian, same as a D4A trust. Again, in these cases, the beneficiary could be over the age of 65, but as I said, New Mexico doesn't doesn't abide by that. We still have to be 65 or under for a pooled trust. And the nice thing about these pooled trusts, because again, we're using beneficiaries' own funds. If you look at the top line under the green lettering, beneficiary transfers his or own funds. Again, we're typically talking about money that the beneficiary owns or assets they have. Instead of the remaining assets at their death going to the state, the assets go to the nonprofit. So you're able to actually to help a nonprofit rather than add to the coffers of the state. So far, as I said, the ARC of New Mexico and ARCA are the two that are approved and operating in New Mexico. We did have a few others previously, but the State Regulation and Licensing Department determined that because they're trusts, they need to be regulated as a professional trustee would, and required a lot of certification and follow-up from the entities, and ARC and ARCA are the two that followed up and did that, and they are now regulated by the Department of Regulation or Licensing and Regulation, so they can't just run off with stuff. So a great alternative depending upon an individual's needs, and something that we definitely want to explore in the right circumstances. Next slide, please. All right, third-party special needs trusts. Now these, as I said, are a great option for somebody else's money. So when you have an individual who's going to inherit from somebody, or someone wants to give a gift to a family member, this is the type of trust that allows us to do that without becoming a Medicaid payback trust. They can be what's called inter vivos or testamentary trusts. Inter vivos means during a lifetime. I like to call that the standalone trust. The testamentary trust is usually one that comes out of somebody's will, and those are created at the time of that individual's death. They're funded with assets that do not belong to the beneficiary. So when my example before, when I said that a family member wants 20% of their estate to go to their family member Sally, and Sally has a qualifying disability and receives Medicaid and Social Security, we don't want Sally to get those funds outright, because then we're going to have to put them in a D4A trust, which is a payback trust, which means Medicaid gets anything that's left at the end of her life. Instead, we want family member to say, I give 20% of my estate to Sally's special needs trust. And that way the funds bypass Sally, go directly to her trust, and they do not require that it be paid back to Medicaid at her death. So she can, or the grantor, the creator of her trust, can decide who the beneficiaries are going to be at Sally's death. Again, these trusts do need to be irrevocable. I'll try that, make it very clear. They do need to be irrevocable. We always like to send the trust to Social Security and Medicaid at the time that they're created to have them approved by those two entities. If the trust is being drafted by somebody who knows what they're doing and is familiar with the various differences between the types of trusts for special needs individuals, these trusts will be approved by Social Security and Medicaid. If the trust is one that was created off the internet or with somebody who's not familiar with them, it is incredibly important to verify that they are approved and they do have all the appropriate language. You don't want to find out 1, 5, 10 years down the road that your trust is not exempt, and all these benefits that have been being paid to the beneficiary now have to be repaid to Social Security or Medicaid. That's not a good letter to get in the mail. As I said, with these types of trusts, we can direct where the rest of the trust at the end of the beneficiary's life will go. So we can name other family members, charities, friends, anybody that we want to name. It does not have to be Medicaid or the state of New Mexico. And we can also leave it to a pooled trust. So the pooled trust can be the beneficiary of a third-party settled special needs trust. Next slide, please. All right, I want to talk a little bit about the Secure Act, because while it has its own crazy stuff about retirement plans and what you can withdraw from IRAs and all those kinds of things. There are some provisions in there that are particularly important for folks with disabilities who have special needs trusts. Whether you have IRAs or 401ks that qualify and you're worried about the stretch that to allow the beneficiary to continue to take the distributions or not, what's important is actually the next slide. So I want to jump to that. And that's the exceptions to these changes to how we can take our retirement. So under this under the Secure Act, the changes were made to how people can take their retirement distributions and how they can leave retirement distributions to family members. The life expectancy payout, and what that means is instead of being taxed at my tax rate, which is much higher than my retired father's tax rate, under the old rules, I could stretch his age out and continue to receive a benefit from his IRA at his tax bracket during my lifetime. Well, that changed with the Secure Act of 2019, but they made some exceptions to that change. And the important one for us in this case is disabled beneficiaries and people with chronic illnesses or trusts for the same, which means if you have an IRA and you want to leave that IRA to an individual with a disability or to their special needs trust, you can do that and still get the stretch, the categorization of the tax bracket from the retired person, not the individual who's the beneficiary. So it's a good tax planning tool, and it's a good way to leave something to somebody with a disability who or to their trust in order to minimize the tax implications for a retirement benefit that you might leave to someone. So just something to keep in the back of your mind, not to to worry too much about. Hopefully, when you're talking with your attorney about creating your special needs trust and different benefits that they may get from you at the end of your life, especially if we're talking about parents and children, something to keep in mind, and hopefully your attorney will talk with you about that as an option. Next slide, please. All right, I told you I wanted to talk about ABLE accounts because I think they're a really wonderful opportunity, and they can work in conjunction with a special needs trust, or they can be a standalone way to kind of keep some extra money for an individual. So in 2014, the ABLE Act was passed by Congress. And it's a portion of Section 529 of the Internal Revenue Code. Most people are familiar with 529 as a college savings plan. People hear about 529s to invest money to pay for your kids to go to college, in which 529s are fantastic. I have them for my kids, but this is a different provision. And there's similarities to 529 plans, but there's also differences that are important to remember. Much like a 529 plan, it is an income tax deferred account. So you're not paying income tax on that asset like you would on an investment with your financial advisor. Anyone, including the beneficiary, can contribute funds. So the beneficiary, and this is great for a lot of people who are able to be somewhat employed. They're not necessarily full-time employees, but they can work some to contribute to their needs. But they're not completely self-sufficient, so they still need their Medicaid and their Social Security. But they want to work, and they want to earn more than $2,000 a month. That excess income can be diverted into their ABLE account for them as a savings account. You do have to be a qualified disabled beneficiary. Again, if you qualify for Medicaid and Social Security, you're going to meet the requirements for an ABLE account. So that's pretty nice to know. The beneficiary actually owns and can control the account. So unlike a special needs trust where the beneficiary is not the owner and has no control over it, the beneficiary absolutely can control their ABLE account, which means they can decide if they want to take funds out to use them for something, or if they want to save, or what they want to do. Like with everything else in life, this is a good and bad. If you have a beneficiary who is just going to run through money like crazy, the minute it goes in, it comes right back out. Maybe you want to think about other options for how to manage their funds. It can also be a great tool to help people learn how to manage funds. I have a client who has an ABLE account and also a special needs trust, and to kind of help him have independence in spending money, but also control it a little bit. The trustee of his special needs trust puts money into his ABLE account for him from the trust periodically, and he has total freedom as to how to use that money, but he's not, completely wiping out the rest of the assets that he has. It does allow for qualified disability expense distributions, which includes housing. So a qualified disability expense distribution is basically the things that the person needs that, again, Medicaid and Medicare don't cover. The list is a little bit different, and so if you do choose to set up an ABLE account for your family or friend, or your family member, or your friend, whoever, consider taking some time and looking at the various things that can be paid for. Much like a special needs trust, a trip, meal out, a new computer, a car, lots of different things that can be used, special therapies that aren't approved. But it is important that you're going to open one of these accounts and you're going to make distributions. Take a look at the qualifying distributions and what the expenses are. But the important part about this, and the reason I want to really bring this to your attention, is it includes housing. You are allowed to use an ABLE account to pay for housing. Now, those of us that work with Social Security, we know that people who receive SSI benefits cannot use those funds for housing. That's so your $790 a month is supposed, or a month. Whew, if it was a year, we'd be in real trouble. A month is intended to cover your food and your housing, and you cannot use funds from a special needs trust to supplement your housing, but you can with an ABLE account. So one of the things, again, as I said, my client who has both, and I've actually got a couple of clients this way, we put money from the special needs trust into the ABLE account, and then we use the ABLE account to pay for the housing that he wants to live in that costs more than he can afford only on his Social Security. So this is another way that we can use these different tools together to accomplish something really cool for an individual and give them a really good opportunity for a good life. And the distributions are considered non-countable resource. So you don't get dinged by Social Security or Medicaid when distributions are made out of your ABLE account. So again, a nice benefit to have that available to somebody. Next slide, please. Some new benefits that we have available to us. New Mexico has, well, I shouldn't say finally. I used to say finally, but we're getting further and further out from when this happened. New Mexico did adopt the act initially, but we didn't have a way to create an account in New Mexico. That has changed. The limit on what can be in an ABLE account is only $15,000 per year. So it's the same as the gift tax right now. So an individual can add, a couple hundred, couple $1,000s at a time, and that's fine. There's no requirements for a daily, weekly, monthly addition or subtraction, but you cannot contribute more than $15,000 to an ABLE account in one calendar year. The beneficiary may not have another IRA or ABLE account. Unlike 529 plans, excuse me, where you can have multiple. I have a 529 for my kids. My dad and my mom had a 529 for my kids and for my niece and nephew. You can have multiple 529 college plans. You cannot have multiple ABLE accounts. One account per person. If mom and dad open an ABLE account for their child and grandma and grandpa open an account for their child, one of those accounts is going to be considered countable. So one per person. The amount of wages is still subject to the limitations of Social Security. So in order to get your full Social Security benefit, there are limitations on how much an individual can earn. That doesn't change by the ABLE account. It just means that if you go over that $2,000 a month limit, you have a place to put that money and not have to just spend it for the sake of spending it. It can be saved. And this is also kind of nice. A 529 plan can be rolled over into an ABLE account, assuming it's under the $15,000 limit. But if you took out a 529 plan for an individual when they were small and you've got you know, $5,000, $10,000 in it, and you determine that this individual is not going to be able to use it for one of the approved secondary education, college or vocational school or what have you, you can roll those funds into an ABLE account and still maintain the tax deferred portion of that. It's not penalized. So that's a nice benefit as well. Next slide, please. Oops, I think we went maybe a little too far. Yeah, okay, here we go. So again, one account per beneficiary, $15,000 per year. That was the 2020 limit, and I've not received information that's changed in 2021. The disability must have been evident prior to age 26. This is one that we kind of hate. One piece that we hate about the ABLE accounts is, for some reason, there is this qualifying age. So it's a bummer for people that maybe have a traumatic brain injury when they're 45 years old and could really benefit from this. They can't, their disability was not present before age 26, and therefore they're not eligible to participate. We can only have a maximum balance of $100,000 to maintain Social Security SSI eligibility. At $15,000 a year, it would take a while to get up to 100,000, but you know, the longer these accounts are in place, and for younger folks, this is going to probably start to come up. What happens is, if you exceed the $100,000, you still keep your Medicaid, but your SSI is suspended until you kind of spend that down. So if you got over $100,000, you might want to try and convince the individual to buy something, to spend some of that money to get back under that $100,000 limit. ABLE accounts are not the place to put large sums of money. So again, this is different than a trust. Trust can have $1 or $1 bajillion. It doesn't matter. There's no limitation on that. It's a tool to use often either in place of a trust when there's a small amount of money, or in conjunction with a trust when we have a larger amount and we need to do some work with that individual. But this is not a place to think that we can put huge sums of money to hold on to for somebody. At the death of the beneficiary, we pay any outstanding expenses that the individual had, and the balance goes to Medicaid. So this is, again, why we don't want to keep large sums of money in the ABLE account, because we don't want Medicaid to end up with $1 million that's left over. So ABLE accounts are good as a savings account type of situation for smaller things and to funnel money if you make a little bit more than the $2,000 a year. It's a great place for someone to, grandparent, to gift a graduation gift to an individual that they can actually use. And if, you know, if grandma and grandpa want to give them $5,000 for the high school graduation, that doesn't impact their Social Security and their Medicaid, their $2,000 resource limit. They can put it into an ABLE account that the person can then use however they want. They don't have to put it into a trust where it becomes an issue with the trustee to discretionarily distribute it. So a good tool, but again, everything doesn't fit every situation, and we have to talk about the facts of what people need to figure out what the best plan is going to be for them. Next slide, please. So with the ABLE account, each state must pass enabling legislation. And as I said before, New Mexico did that right away. New Mexico really didn't wait too long. We did that in March of 2016. Lots and lots of other states, and they continue to come online. When we started these presentations and we first started talking about the ABLE Act in 2016, and even in 2015 before New Mexico passed it, we were talking about, you know, 4 states, 5 states, 6 states. At this point, we have, I think almost every state has passed this legislation. What New Mexico didn't do in 2016 was create a mechanism for a New Mexico ABLE account. So we would send our clients to Ohio or to Tennessee or to other states that had set up the mechanism within the state and would allow anybody to participate. However, in 2018, New Mexico did begin doing this. Initially, we contracted with Ohio, but now we have our own ABLE portal, and individuals can access that directly through the state of New Mexico. The Treasurer's Office is the one that manages that, and not every ABLE account manager, every state, it manages these accounts the same way. There is a website. If you just Google ABLE accounts, you're going to get the ABLE Resource Center. I believe it's the ARC, if I remember correctly. And it will let you compare and contrast the different states and figure out which one has a higher return on investment versus which one maybe has a little bit higher monthly fee, which one has access that you feel more comfortable with, whatever works for you. And it may be New Mexico or it may not be. And again, it's completely individual, and you need to make that decision based upon your own particular interests and needs. Most people, or most of the plans do have some cost to them, so they have a monthly fee or a percentage or whatever the case may be. It's all electronic. You don't have to go down to Bank of America or Wells Fargo or Newsenda and set something up. It's all done online, and all the financial transfers are all done online. So money will go electronically to your ABLE account, and the ABLE account administrator will electronically deposit money into your own bank account when you want to take funds out. So it's all electronic. There's no actual bank that you go hang out at or physical checks to write or anything like that. Next slide, please. So this is a screenshot of the New Mexico portal. So if you go to ablenewmexico.com, you'll get to this screen, and it helps you walk through the process to open an account. In New Mexico, it's called a stable account. I'm not sure what the ST state, I don't know, but same thing, and you can research the benefits, the eligibility, what the expenses that can be paid out of it are, all those good things right here on this lovely website that the Treasurer's Office has put together for us and manages through their office. Next slide. Something I wanted to bring to your attention too, and again, this is an act that was passed, the National Defense Authorization Act of 2015, doesn't have a lot of provisions in it that we really need to worry about or care about, but there is one, and I think it's important that that everyone kind of be aware of it and pay attention to it. It used to be that military benefits could only be payable directly to an individual, to the military person's child, and that would disqualify them. So if mom or dad were a vet and they had a military benefit that their child would be able to receive, and their child had special needs and was receiving Medicaid and Social Security, and all of a sudden they get this nice lump payment, now child is kicked off with their benefits and they have to spend all of this money on the things that Medicaid and Social Security would pay for. Well, that wasn't too cool. We didn't like that too much. So the National Defense Authorization Act of 2015 made a change, and so now those survivor benefits can be paid into the Special Needs Trust. They don't have to go directly to the child. So that's a wonderful change to allow us to protect those assets so that the child with the disability can use them for the good stuff that they want to do and that they need, and still protect them to be able to make sure they get their Medicaid and their Social Security. So if you are a veteran and if you've got concerns about what might happen to a benefit for a disabled child at your death, know that we can make sure that those funds get into a Special Needs Trust and protect them so your child does receive their continued benefits, which is awesome. All right, next slide, please. Make sure we have enough time. Oh, we do, because that was my last slide. Awesome. So that's pretty much it. If you have questions, I would be happy to answer them, and we can go ahead and stop the recording and answer any questions that you all may have. I appreciate everyone's attention and being here today. I know I threw